I think firstly as well it puts to bed a major objection to the proposed bill, and at the same time it raises the need for administrative and policy support to bring the bill into effect. Where I think it puts to bed a major objection is the Treasury says straight out, overseas experience demonstrates that the introduction of a public benefit test, thus removing the presumption of public benefit, has not caused a significant issues for the charitable sector. Now, focusing somewhat on the Treasury submission, the ATO advises that it already applies the common law public benefit test to applications. Now, I think that statement in the submission does require some clarification, and I can always be picked up on this by the Treasury officials or, of course, other people that are wanting to make submissions. I'm sure will correct me if I'm wrong. But it seems to me that what is applied at the moment to religious charities is indeed a non-test. It's a presumption. The ATO presumes that a religious charity operates by definition for the public benefit. The only occasions on which this presumption is reversed and then tested in a fashion, in my mind, seems to be very haphazard. The Treasury says the common law already envisages situations where purported charities' purposes fail to exhibit public benefit aspects, where public benefit is negligible, and where public detriment outweighs any public benefit. Currently, weighing of public benefit against public detriment or harm is not required. However, the ATO advises that these considerations are at times taken into account by the Commissioner. Well, first of all, I query how can you determine public benefit, firstly, without weighing benefit against harm? The Commissioner of Tax, this is another quotation from the submission, the Commissioner of Taxation can and does revoke endorsement of organisations where there is factual evidence available that the organisation does not provide a public benefit. So, and not only that, just to add another bit there that I think is relevant, the Commissioner does not currently have a capacity to make policy decisions about what should or should not be considered to provide a public benefit. He can only interpret and apply the statute in common law and apply it to the circumstances of individual taxpayers. So, going back to those sections, I think, in other words, all religious charities are presumed to be for the public benefit. It's only under not so far revealed circumstances in that submission where the Commissioner actually happens across or comes across factual evidence that might indicate that the presumption should be tested, but the Commissioner might take these considerations into account. There's no transparent mechanism, as far as I can tell, whereby the reversal of the presumption is triggered. I mean, for instance, does the Australian Tax Office monitor news reports, media reports? Does it monitor tax or monitor court cases for adverse comments about groups? Does it monitor assiduously Hansard, which I presume it does? Does it act on the odd representation if officers feel moved to do so, and if anyone knows that they should write to the Australian Tax Office to object to the endorsement of a particular entity? Because although it's becoming clearer to me after some years of looking at the types of issues and the reasonings involved in this area, it is a very opaque area and difficult for the average citizen to know where to go and who to take their complaints or objections to. I think this state of affairs is entirely unsatisfactory. I think it's inadequate. I think it's not transparent enough, and I think it can be improved. I mean, it's often said that we need to have we need to solve the whole problem first, but we've been looking into these matters for some time, and I think this mechanism for the rebuttal of the presumption of public benefit needs to be looked at and can be addressed, I think, quite easily by this bill and by this committee. The presumption let me have a look here. But the presumption, the state of affairs is entirely unsatisfactory, even if the ATO feels that the presumption should be reversed. In determining whether, in fact, an entity operates for the public benefit, the Commissioner can only apply known precedents and cannot apply his own policy decisions, so the scope for disqualification of problematic organisations is extremely narrow. The central observation here I'd make in an explanatory way is that in England, where the common law of charity developed, the two-pronged definition of religion was relatively narrow, belief in a deity and worship. The definition applied to essentially Christian groups in a country with an established church and was extended incrementally. The presumption of public benefit for religious charities was therefore applied to a relatively narrow or narrower group, with the anomalous inclusion even there of Buddhism, for instance. Now, with the advent of multiculturalism, plural faiths in our modern societies, and lots of immigration where people bring their faiths with them, we have expanded, we've tended to expand this definition of religion. So it was felt necessary to widen the definition of religion, and in England, where they've moved to codify these laws, they have widened the definition of religion somewhat in England, still not to the width that our definition entails, or our alleged definition entails, but at the same time they've removed this presumption of public benefit. So the whole purpose there is to keep some sort of regulatory control over non-conforming or problematic groups. Now, I'm not naming any names, and I won't at the moment. The point is that I think people are concerned about some groups that are non-conforming, in that they might cause some harm to their adherents and harm to people in the public as well. Now, the problem with the Australian situation, as I see it, is the sort of reverse trend has happened, in that we had a case in 1983 which we called the Scientology case, and in that respect Scientology does feature prominently in the major public policy decisions that are made by the courts and governments. In that decision, the reverse has occurred. So the ATO and other agencies have, incorrectly or correctly, I'm not sure, implemented a widely inclusive definition of religion, but at the same time they've continued to accept the now outdated presumption of public benefit. This laissez-faire approach, in my view, allows a loophole through which all sorts of undesirable groups can gain access to tax-exempt status as religious charities, subject only to an admittedly very ad hoc application of a public benefit test. Now, with respect to religious institutions, where it's noted that the Treasury states that there is no common law public benefit test in relation to working out whether or not an entity is a religion, and perhaps indeed religious charities, I wouldn't be surprised if the basic definition of religion applied by the ATO is in fact an ethically neutral definition, because the 1983 Scientology decision on this point is not entirely clear. The definition derived for administrative purposes from that case is belief in a supernatural being, thing or principle, and canons of conduct giving effect to that belief. Well, that begs the question, do canons of conduct giving effect to a belief have to be ethical canons of conduct, or are they merely mechanical or ritualistic? Could they really be just applied to an ancient Bacchanalian cult? Okay.
We might ask you to finish soon, because we have only a limited amount of time.
I'll come back to this then if I finish sooner.
And then
all right.
senators could ask you questions, but if there are other important points you want to make...
I'll come back to them then. So I would submit, first of all, that the legislature could require a positive ethic in any definition of religion, and this is not precluded, in my view, by the 83 case. I'll open it up to senators for questions. Thank you very much, and I'll come back to some of my points.
One of the problems with Senate committees is that we have lots of interesting witnesses but limited time, so that's why submissions are so important. You've tabled to a document and a CD. Is it the wish of the committee that these be accepted? Yes, thank you very much. So they are so tabled. I might just ask you a question, Dr. Mutch, and that is the public benefit test proposed by the bill will be contained in regulations. Some submissions the committee has received have criticised this aspect of the bill. From your experience researching in this area, do you think that the proposed approach is desirable, or would you like to see the bill modified? And if so, how would you like to see it modified beyond what you've said already?